Welcome to a new series of the Hip Talks podcast, a collection of discussions on legal topics hosted by Hugo and Ip solicitors. We provide high-quality legal services with integrity, professionalism, and respect for our clients and the community. Our solicitors have achieved outstanding results and recognitions in the areas of dispute resolution, corporate and commercial, private client, probate and trust, family, employment, business immigration, and data privacy.
Hi everyone, I'm Jacqueline Cheng from Hugo and Ip, and I'm here today to do a podcast with Alfred Ip, the partner of Hugo and Ip.
Hello, Jackie.
Hi, today we're going to be talking about estate administration mostly. But before I do that, I have a hypothetical question to present to you first.
Okay.
So Alfred, if hypothetically a family member of mine has passed away and I'm in a fluster, what is the first step that I should be doing?
The first thing that you have to do is to deal with the grief of you losing your family members. You have to put your mind at peace because I know that it must be tough for you, but then it takes time to heal. And afterwards, after you've done all the funeral and dealing with all the postmortem matter, it's time for you to handle his or her estate. And by that time, you can come to me and I'll guide you through the way.
That sounds good. So what would be the first step?
I think the first step is to identify the assets that you need to administer. Because in the estate administration, the first thing is to apply for a grant of probate. And in the grant of probate, there will be a survey of assets and liabilities. And this survey has to set out all the assets that the deceased had under his name. Without stating it in the list, you cannot administer it. So it's actually quite important to identify the assets in the name of the deceased.
So if my family member had assets in like Canada as well as Hong Kong, do I still need to put those assets in the grant?
Not in Hong Kong grant, but you may have to do a similar process in Canada. So actually, you have to also to identify whether the will, if there is a will, is applicable to the Canadian assets as well.
What if I'm unsure the types of assets my family member has in Hong Kong?
Then we have to find out for you. There are a few things that we can do for you in order to find out the assets. Usually there are these kind of assets, bank accounts, share certificates, or safe deposit box. What would be the best way to proceed the first step?
So from my understanding is that in Hong Kong, there's actually no centralized system in which I can just put in the deceased name and then get a list of all the assets that the deceased has in Hong Kong.
So you're correct. What should we do?
Usually, I think bank accounts is usually the best way forward because most deceased would have bank accounts in Hong Kong. And for this, we usually have to actually write to each individual bank to see if the deceased holds an account with them.
But there's so many banks in Hong Kong. Where to begin?
So usually we would go through the deceased papers, personal belongings first to see if there's any letters or bank statements that the deceased is still keeping. And then we'll ascertain and write to those banks that we found statements for. Otherwise, we do recommend that if you completely have no idea, then we would probably suggest to write to the top 10 banks in Hong Kong first to see if there's any, if the deceased holds any accounts with them.
Like HSBC, Standard Chartered, Bank of China, and the Citibank, things like that, right?
Right, correct. Do you think private investigators would be a good source as well?
Yes, actually, a lot of the private investigators, or we call it data collection agencies, they maintain a record of all the public records, such as land searches or company registries. That would be a very good start. You have no idea about anything regarding the deceased assets.
That's good to know. So now that we've ascertained the assets, my next question for you, Alfred, would be, after the grant is obtained, how would I I believe most of the bank accounts would be frozen. How can I unfreeze them and get access to those funds?
Well, you would have to send the probate to the banks and ask them to cancel the deceased accounts and transfer the proceeds to the designated account for estate administration.
Would there be any legal documents that will be involved?
Well, definitely the grant of probate that is issued by the Hong Kong court. And the bank would then usually make a rubber chop on it to show that it has been administered.
Okay. I believe the next question I have for you that I actually got a lot of clients asking about are safe deposit boxes. Usually they come to us and tell us that they have no idea what's in the safe deposit box. So how would the administrator or the executor gain access to the safe deposit box's items?
First of all, they have to make an appointment with the Home Affairs Department. The people at the Home Affairs Department would take an inventory list of all the items in the safe deposit box of the deceased. Irrespective whether those items belong to the deceased, they would write down a list, and that list will be included in the probate that will be issued by the court.
And would I need to go back to the bank to collect these items?
Yes, after grant of probate is issued, you have to go back to the bank and ask to cancel the box and get everything out.
So what if I don't have any items? They took the inventory list and they found nothing in the safe deposit box. Do I still need to go back?
Yeah, you still have to go back to cancel the box, otherwise you will have to continue paying the rent.
Oh, that's good to know. Now that we've gone through bank accounts and safe deposit boxes, I think there's a lot of clients that are actually interested in landed property in Hong Kong. How would you go about doing that? And another question is, would you sell the property, or can I just simply transfer the property to the beneficiaries?
It very much depends on the family consensus. After the grant is issued, the executor or the administrator has the power to sell the land property. But then, of course, if the family wants to keep the property, the administrator can transfer the legal title to the beneficiary. The only question that we have is, if, let's say, there are like 10 beneficiaries, it is undesirable to transfer the legal title to all 10 beneficiaries who are entitled to share the property, because it would be difficult for the beneficiaries to come to consensus to sell the property at the same time in future. So, if that is the case that a lot of beneficiaries are entitled to share one landed property, perhaps the best way to do it is either to sell it after the grant is issued, or to agree among the beneficiaries to have one or two of them buying out the other beneficiary shares. And to come about it is to enter into a deed of family arrangement among all the beneficiaries so that they understand that their assets their interest in the properties will be relinquished or bought out. But of course, the disadvantage of it is that this deed of family arrangement will be subject to stamp duty. And nowadays, as you know, stamp duty is quite high. For those who already have landed properties, it's 15% for residential properties. So this perhaps is part of the legal advice that we will give when people are considering the estate planning. If there is any landed properties, it's better to make specific provision for it so that you will end up in one or two beneficiaries without them ended up with a deed of family arrangement and have to pay stamp duty on it.
But if that's the case, if one of the beneficiaries, let's say, already owns a piece of property in Hong Kong and they simply want to become the owner of the estate landed property, would there be tax implications?
If he is the designated beneficiary of a particular piece of property, all the executor needs to do is to transfer the legal title to him, and that would be a document called assent. The assent is the document that transfers the legal property to the beneficiary, and in that respect, there is no stamp duty. There only needs to be a nominal stamp duty, I think, around $5 Hong Kong dollars or 50, something like that. That is insignificant.
You mentioned an assent. Is this some sort of legal document that needs to be drawn up?
It is a legal document that should be drawn up by lawyers because that preserves the legal title. In the future, if that property is to be sold, the person who buys the property have to ascertain the good title. And this is why the assent should be drafted or drawn up by lawyers.
What if I wanted to just, going back to selling the property, can the executor and administrator simply be able to sell it on behalf of the deceased?
Yes, the answer is yes. But then there is a big issue that the administrator or the executor must look into. He or she has the power to sell the property, but he or she has to sell the property at or above market value in order to protect the interests of the beneficiaries because it's their duty. Otherwise, they should seek consent from all the beneficiaries, and the beneficiaries should understand that they are indeed selling the property at the undervalue, and they should have specific consent to it.
Thank you, Alfred. I think you've given a lot of good information in regards to dealing with landed property in estates.
Yeah, and in that respect, how about other properties such as company shares, like public company shares?
In regards to public shares, I think one of the main queries that a lot of clients do have is whether they can just liquidate the shares in Hong Kong once they get access to it. And from my experience, the answer is not as simple, especially if the client is living overseas and doesn't have some kind of brokerage account to deal with it. So Alfred, do you know like what the client should do if they're overseas?
Well, first of all, they should ascertain whether the shares are actually in a brokerage account or with a share certificate. Share certificate is something very old. Nowadays, with the CCAS, we call it, not many people would hold the actual share certificates of a public listed company. But then we come across a lot of elderly who keep on their share certificates, put it in their safe deposit box. So in order to liquidate the shares, it become an issue. How can they do that?
They'll have to liaise with the shares registrars. A lot of times, from what I've seen, is that if they simply want to liquidate it, then they'll have to prepare a standard form of transfer. And this document allows the transferor to basically transfer those shares to the transferee. And the transferee is usually a third party that would be able to help them liquidate the shares in their brokerage accounts. Do you know whether there could be stamp duty involved if they were to they were to prepare a standard form of transfer?
Yes, I understand it's 0.02%.
That's from my understanding as well.
Very good. I'm correct.
So what if they decide to would you recommend that they liquidate all the shares, or due to the market fluctuation of the market, a lot of beneficiaries have come to me and says that they actually do not want to liquidate those shares? What can they do?
I think the easiest way to do is to liquidate the shares and distribute the cash to the beneficiaries. And if they consider that it is necessary or it's wise to keep the shares, they can always buy it from the market with the distribution that they receive. There's only 0.02% of the stamp duty involved and a small percentage of brokerage fees. So it's relatively insignificant. I think it's more important for the administrator to discharge their duties properly, including effective administration of the estate, so that they won't be blamed in future by the beneficiaries for delay in estate administration.
So now that we've dealt with public shareholdings, what about if the deceased was a sole shareholder and a sole director of a company that they incorporated in Hong Kong?
That actually becomes an issue because a limited company is a separate legal entity. And if the deceased being the sole director and sole shareholders of a limited company, that limited company becomes directorless when the deceased passed away.
So what does that mean, director?
That means that no director is appointed as the director of the company. And because if the deceased is a shareholder, is the only shareholders, no resolution can be passed to appoint another person to become the director of the company. So in order to avoid that, we always advise our clients to appoint a reserve director before they passed away, so that the company would not be left in a limbo. And a lot of time, these kind of sole director, sole shareholders company are used as assets holding vehicle. That is, client put assets into the name of this limited company as part of the wealth management and planning purpose. The last thing that they want is to leave the assets with a company with no directors and with only deceased shareholders. The process would be that the administrator has to, first of all, seek a grant of probate in order to get hold or get control of the share of that limited company, and exercise the power as the shareholders to appoint someone as the director of that company before that person can do anything on behalf of the company.
So does that mean that director doesn't necessarily have to be the administrator or executor?
Yeah, it doesn't have to be, but of course, that person must be someone that is reliable or trustworthy in the eyes of the administrator, because that person will be the one who wind up the company, get control of the assets held by the company, and put it back to the part of the estate.
Is it possible that that person continues to operate the company instead of dissolving it?
Well, it very much depends on the nature of business of the company. If that company has an operating business and that person considers himself capable of handling the business, yes. But then, of course, if that person is not the administrator, then the administrator is effectively entrusting that person to manage the estate of the deceased. And that person must be someone with the necessary skills and knowledge to discharge the part of the duties of an administrator. Otherwise, it would be borderline breach of administrator duties to the beneficiaries. So it is something that has to be carefully considered before making a decision on that.
That's good to know, Alfred. I want to turn our attention to another type of asset that is, more Hong Kong related, would be mandatory provident funds.
Yes.
A lot of beneficiaries have actually come to us, have had issues accessing these funds. Their main concern is how will they be able to ascertain the amount before they get the grant, and how can they actually claim this MPF?
I think a lot of people do have the misconception that MPF is like insurance policy, and deceased can, in their lifetime, name someone as a beneficiary in order to get hold of these funds after he passed away without the probate process, which is not true. MPF is just like a bank account. Without the ability to name beneficiary, it must form part of the estate. And the person who passed away and the administrator of administering his estate has to ascertain by informing the MPF service provider about the demise of the deceased and find out whether there's any money left in the MPF account. So would the MPF service provider provide this kind of information?
It actually depends on which MPF service provider. I have come across that there are times when a lot of them have asked that we present the grant to them first before they will let us know the amount of MPF that we're able to claim.
This is very different from the banks who are normally willing to disclose this information to the intended administrator.
That's correct.
So to actually increase the difficulty in the state administration.
Yes, because in a way, then you'll have to go back and amend the grant again with the required information before they will release the MPF.
That's not very nice, but then they are a little bit stiff in handling requests like that.
Yes, it's been a difficult process, that one.
Yeah. Another part that is also a lot of attraction, or actually a lot of people ignored, is tax. Hong Kong has always had a very simple tax system, but then a lot of people do not realize that actually tax forms part of the estate administration. Jackie, can you share your experience on that?
So a lot of times clients come to me first. I'll have to liaise with the Inland Revenue Department in Hong Kong to see whether the deceased has any tax refund or whether there's actually tax liabilities that we have to settle in the future. Usually they would come back with a tax return form for us to complete, and then we'll have to fill it out and then return to them. And then a few months later, they may come back and tell us the result as in whether we actually have to pay them, settle any debts, or whether we actually get a refund. And it actually may surprise a lot of people because a lot of times I've seen is that the deceased may actually have a tax refund for them. And this is interesting because in Hong Kong, you actually have to pay years in advance for the tax. So if that person passes away before the year ends, then they actually get a refund from their salaries tax, let's say.
Yeah, this is something that a lot of people do not understand because there's a provisional tax that any person will have to pay every year. So at the end, if that financial year, the income was actually less than the previous year, there will be tax refund. So I think that emphasizes the importance of having an experienced lawyer helping the administrator to make necessary inquiries in order to ascertain the assets of the deceased and move through the administration process so that there won't be anything left.
Yeah, that's actually very helpful. Usually it is knowing what debts and what assets are present will help the estate administration process a lot.
Yeah. And another thing that is what I've just mentioned, MPF, that is not insurance policies. How to handle insurance policies?
Insurance policies is actually a very interesting one because not only are there different types of policies, but there's also policies that may not fall into the deceased estate. And this is the case when let's say you've applied for these policies and you've actually named beneficiaries that are to take over that can make the claim after your passing. So when you have named beneficiaries, then technically that insurance claim doesn't fall into your estate, the deceased estate, and instead it would go directly to the beneficiaries. However, when there's no named beneficiaries, then the claim will actually fall and we have to distribute it in accordance to either, let's say, the will or intestacy law in Hong Kong.
And insurance policies not only involve insurance policies that were taken out by the deceased during his or her lifetime for the purpose of either assets planning or protecting the families. A lot of time, we also come across insurance policies taken out by the employer of the deceased at the time when they were employed by the company. A lot of time, actually, it becomes quite difficult to find out. Jackie, in the course of your experience, have you come across this kind of cases?
Yeah, there's actually a couple of cases that I've had to assist with where insurance companies were actually not willing to release any information to us at all. even if, especially the case if there's named beneficiaries. Insurances are very protective and they keep everything confidential. So the only way to resolve it in the end was to just make almost, you can say, random applications to them claiming that you're the beneficiary. And if you turn out to be that beneficiary, then they will be happy to release the money to that beneficiary. But otherwise, they will not release any information to you at all.
So, in that case, perhaps the only other person who know anything about the insurance policies is the employer, who have taken out the insurance policies for their employee as employee's advantage or employee's benefit.
Correct. So perhaps the administrator or executor should contact the deceased employer to see if they were able to assist them with giving them that kind of information.
Okay. We've talked about many types of assets that are required to be administered in the estate administration. How long would it usually take for estate administration?
That's actually a very difficult question because it all depends on the complexity of the estate. Whether there's a lot of assets to handle, how many beneficiaries are involved, would it become a contentious matter if there's, let's say, more than one beneficiary that can inherit the estate. Usually, most administrators or executors will try their best to probably get everything done within a year's time after the issuance of a grant. But if it becomes a complex case, then sometimes it will take longer.
I can imagine that. And for administrators who are not residing in Hong Kong, definitely is going to be more difficult and take more time to administer the estate.
Is there any, if they don't reside in Hong Kong, what is the easiest way for them to actually administer a deceased estate?
I think the easiest way is to authorize someone like a practicing lawyer to administer the estate for them in Hong Kong so that they don't have to come back and forth and sign all the papers that are necessary, usually in front of a notary in the place that they reside. And that actually adds another layer of complexity because if the administrator actually do not reside in Hong Kong, if they need to communicate with all the financial institutions about estate administration, they will be more cautious about ascertaining the identity of the person and executing his or her instructions. And there will be more bank charges as well if they are required to remit the deceased estate to a designated account overseas. So it's definitely more convenient to have an administrator within the jurisdiction to deal with all this estate administration and make the distribution within Hong Kong.
So does Hugo and Nip able to offer this service?
Yes, and we do that all the time.
As I'm assuming we actually get a lot of overseas clients that require this kind of assistance.
Yes, and they actually need that kind of assistance because they're a lot of time not familiar with the Hong Kong system, which can be very different from the country where they reside in. And without necessary guidance or assistance, they will find it very confusing in the estate administration. So that is the role that we have to play, basically deal with the whole process for them.
My understanding is that what if a creditor comes along and asks and has a claim against the estate?
I think for the administrator, it is their role to ascertain whether the liabilities does exist. If the liability does exist, the amount is not disputed, it is within their duty to repay those liabilities before making distribution to the beneficiary. So a lot of time the creditor will require the administrator to execute an undertaking to pay all the debt after calling in the assets before they are willing to allow the administrator to become the administrator and administer the estate.
Is there a time limit as to the creditors can bring against these claims?
That is the reason why we advise the administrator to always seek a court order and ring fence the time that the creditor may bring the claim against the estate, and that we call a Rule 60A order. After getting the order, a notice should be placed in the Gazette in order to notify anyone who may have a claim against the estate to make their claim within 2 months. And this is very important for the administrator to do this before making distribution.
So I'm assuming that after the 2 months, the beneficiaries can then liaise with the administrator and executor to finalize the matter?
Correct. After the 2 months, if the administration is completed, it will be the time for the administrator to make distribution. And before making distribution, they should prepare an estate account, clearly setting out all the assets according and the expenses that have incurred, the liabilities that have been repaid, and the remaining amount that will be distributed to the beneficiary.
What if it turns out that the estate had more liabilities than assets?
Then it becomes an insolvent estate. If that is an insolvent estate, the beneficiary will not get anything. But the administrative costs will be deducted from the estate first. And if necessary, the administrator should seek a court order in order to make sure that the distribution of the assets will be in the creditor's interest. And that usually would be in pari passu. That means that if there is a $100 debt and there's only $10 of assets, the assets will be distributed in accordance with the amount of debt that each creditor in their respective proportion.
That's good to know. So am I correct to assume that the administrator or executor would not be personally liable for these to settle all the deceased debts?
They will not be personally liable to settle the deceased debt, but they have to discharge their duties properly in order not to attract any personal liabilities in the course of administering the estate.
I want to actually turn our attention more to the distribution of estates in Hong Kong. What is usually the first step when it comes to distributing an estate after you've, let's say, paid all the liabilities?
Well, the first thing is to ascertain who are the beneficiaries. And in order to determine who are the beneficiaries, it depends on whether there's a will. And actually, in terms of intestacy, a lot of people have the misconception that, for example, when there's an estate in Hong Kong and the person died intestate, the beneficiaries would be in accordance with the intestacy rules in Hong Kong. That is not per se true because it depends on the deceased domicile. And actually, that is something that a lot of time do raise confusion because the domicile of the deceased only governs the personal assets that should be distributed. In terms of the real estate in Hong Kong, the intestacy rules follow Hong Kong, where the property is situated. So the administrator is tasked to make sure that the person who are the beneficiaries are receiving the right share of the estate under the right rules.
But what if the beneficiaries together end up saying that, oh, I don't want to follow what's written in a will and I don't want to follow the intestacy law? Is that even possible, or are they forced to, let's say, follow what is exactly written under the will?
Yes, it is possible. And we come across a situation when the beneficiaries actually want to disclaim their entitlement, their estate, because potentially the tax issue. And in that respect, we also advise the client that the beneficiaries can enter into agreement to redistribute the estate among themselves to their satisfaction. And that would be done by way of a deed of family arrangement. It's effectively an agreement among the beneficiaries to distribute the estate according to the agreement. But then there is a fundamental concept that we have to explain to the beneficiaries. It is not disclaiming their own interest in the estate. It is an agreement for them to transfer their shares of the estate to another beneficiaries with or without consideration. And that is particular in terms of real estate because, as I said, such kind of transfer would attract stamp duty, and stamp duty can be quite high in Hong Kong for residential property. So it is important for them to understand what is the potential tax liability for any agreement to be made among their beneficiaries when they're entering into it.
I remember you mentioned a deed of family arrangement before as well. It says the word family is used in it. Does it necessarily mean just your family members?
No, actually, it generally means the beneficiaries that are entitled to share under the estate. And a lot of time it's family members because especially when there's the intestacy rules in place, only family members are entitled to share in the estate. That's why it's commonly known as deed of family arrangement. But if the beneficiaries are entitled to share and they're not family members, it doesn't stop them to enter into this kind of deed in order to redistribute their shares in the estate.
Thank you for clarifying that. What if, let's say, the beneficiary resides outside Hong Kong? Is it going to be an easy process for us, for administrators, executors, to transfer the funds or assets or items to the beneficiary?
I think it is not just about beneficiaries residing outside Hong Kong. Also, those who are residing in Hong Kong, before distribution, it is particularly important to make sure that they would not have any claim against the administrator of the estate after receiving the distribution. That's why we usually need them to sign a beneficiary instructions in order to confirm that they are happy with the inheritance that they are going to receive from the administrator and they have no claim against the estate. For those who are residing overseas, they are usually required to sign the instruction in front of a notary to ascertain their identity. And usually we would advise the beneficiaries to seek independent advice on their liability in receipt of the inheritance. That is particularly the case when they are residing in high-tax jurisdictions such as US, UK, or Canada, or Australia, because they may be under a liability or duty to report such inheritance to the authority because they may have to pay tax on it.
Great. So I guess today we've talked about mostly three steps in estate administration. It's collecting of assets, paying debts and liabilities, and then how would we go about distributing the estate to the beneficiaries. I think that pretty much sums up the estate administration part of this podcast. Do you have anything else to add?
I think the only things I want to add is that dealing with the Hong Kong estate is only the first part. After receiving the grant, if the deceased has assets outside Hong Kong, it's time to look into how to administer the foreign estate. The foreign estate reward succession process may be completely different from the Hong Kong process, which may or may not require the Hong Kong grant of probate, and there might be steps that should be taken before the grant of probate is issued in Hong Kong in order to make sure that the succession process in other countries can be carried out as soon as possible, probably alongside with the Hong Kong estate, in order to make sure that the beneficiary would receive their share of inheritance quickly. And this is particularly the case when we are talking about a jurisdiction with inheritance tax, such as UK. For example, let's say if a person passed away in Hong Kong with a will in Hong Kong, it may take 2-3 months to get the grant of probate in Hong Kong, and then the Hong Kong grant can be resealed in UK before the UK assets are to be administered. But then one thing that has to be particularly concerned is the duty of the executor to make an inheritance tax declaration. If I remember correctly, there is the time limit that the executor should make the inheritance tax declaration to the HMRC. And if I remember correctly, that's 12 months. If the executor failed to do that within 12 months, there will be penalty. So I think it is important for the executor or administrator to go to a lawyer who has the international estate administration experience to help them through the process and to take necessary steps, including liaising with the foreign lawyer to help them with the estate administration process as soon as possible. Don't wait until the very last minute because that is the part of their duties to administer the estate promptly. And another example before we wind up is that different countries with different legal system may have a very different process. For example, the continental European system, the succession process is very different. And one particular feature is that there's no administrator or executor appointed to administer the estate. Usually it's the family members, we call them heirs, who goes to a notary public to execute all necessary documents. And it is the notary who has the duty to ascertain the person who is entitled to share the estate and the identity of the beneficiaries and help with the estate administration. So it is important for family members to understand in the first place how to administer those part of the assets, and if necessary goes to the relevant lawyers, foreign lawyer with necessary experience in this kind of process in order to do everything smoothly. And one of the aspects is providing necessary documents to support to prove their relationship with the deceased, and that may involve getting the birth certificate or marriage certificate, and legalization may also be an additional process to prove the genuine veracity of these documents. So, to sum up, estate administration can be quite complicated with a lot of countries involved, especially, and it is important to have the right process in place in order to wind up the estate administration properly. Do you have anything to add, Jackie?
Nope, it's been a very informative day for the podcast, and I've really enjoyed it.
Thank you. I hope that people who listen to it will find it helpful.
Make sure you tune in to our other episodes of the Hip Talks podcast by checking the Insights section at our website at www.hugoandip.com. You're welcome to send your comment to our email address hello@hugoandip.com. If you found this episode to be insightful and helpful, please share it with your friends, family and business associates, along with other episodes of the Hip Talks podcast. For the hearing impaired, you can find the notes and the transcripts of this episode on our website. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.